Hey, what's up guys? And in this video, we're gonna talk about the land contract and how it works for real estate investors. Okay, let's get started. All right, the land contract, or another name for it is contract for deed, is an alternative to the installment sale. Now, if you're not familiar with these terms, I'll just break them down for you. When you're engaging in an installment sale, so if I was going to sell a piece of property in an installment sale to this buyer right here, what I'm essentially doing with my property when I sell it to them is I'm acting as the bank on this deal. So this buyer will pay me money every month, okay, just like you would on a mortgage. It would come back to me on a monthly basis, and so I'm carrying the contract essentially when I sold this property on an installment sale. Now, in this scenario, in an installment sale, the buyer becomes the title holder of the property. All right, so the property is now transferred into the buyer's name. So with the installment sale, buyer owns a property, buyer's responsible for it, insures it, does everything they're supposed to do. If anything goes wrong with that property, somebody's hurt on it, buyer's going to be responsible because they're the owner of the real estate. From a seller's standpoint, using the installment sale, well, you can see what would happen if buyer missed a few of these payments to you. What do you have to do to get the property back? Well, you have to foreclose. Now, the foreclosure action can take upwards of 6 months. So it can be time consuming for you to do this. And then you can have other rights that are available, redemptions for the buyer. So a lot of sellers don't like that idea. And so they shy away from the installment sale and they lean more towards a land contract or contract for deed. In a land contract or contract for deed, title does not transfer to the buyer. Okay, the buyer does not get title here. Title remains with the seller. The buyer receives what we call equitable title. All right, so that means they're on title. I mean, they're not on title. They have this equitable title in the property via the contract. So this is a contract you put together between the seller and the buyer. And it states that the buyer is responsible for everything associated with that property, taxes, the mortgage, because sometimes, there may be a mortgage on this property that you're selling to someone. So they're responsible for all of that. But title still remains in the seller's name. And this is kind of, it's good for a seller if there was a mortgage on there and they wanted to sell it and not alert the bank to the fact this property's been sold. The bank would never discover it because it's still in the seller's name. Well, if the seller was smart, they would have it in an LLC. Now, the benefit now of this type of transaction is if the buyer misses these payments down here, you don't have to go through the foreclosure process. You can now move in and go after them for contract forfeiture. And what that means is that you bring an action in court. It's kind of like an unlawful detainer action. You say that this party over here has not been paying under the contract, and now the contract, they've forfeited their rights, and so now the contract's null and void. So title doesn't have to transfer back to you because it remains in your name. It's just that they now lose their equitable title. You evict them from the property and you move back in, you can sell it to someone else. Now, there are some concerns, depending on the state in which you live, trying to engage in this. Make sure you consult with a knowledgeable attorney in your location to make sure you're following the laws, because this is an area where there's not a lot of uniformity, meaning that each state kind of has their own little unique take on this, because they do want to provide some protections for buyers. For example, in Texas, the buyer receives full title to the property once they record the land contract with the county. So then you would have to go through a typical foreclosure action to get the property back. But if you're thinking about doing this, one of the things that I would recommend you put in your contract is an acceleration clause. And what this means is it gives you the ability to accelerate all the payments are due under that agreement if the buyer defaults. See, the more protections you can have inside of there, the better off you're going to be. Because if you didn't have that, and the buyer started missing payments and you wanted to go after the buyer and you didn't want to take the property or cancel out the contract, then you'd basically have to sue for each individual payment that the buyer has missed. Whereas if you have an acceleration clause and they default, then you can come in, you can sue, and then you can go after them for everything else. And this would only be beneficial to you in a situation where the property is no longer worth what it was when you sold it to that individual. Which brings me to my next point with this type of transaction. Now, obviously, from the seller standpoint, it's great that you still hold title. From the buyer's perspective, I mean, you got some risk there because the seller could go out and remortgage a property, get another couple liens on it. So as a buyer, you don't know what the seller's doing, and you run the risk that they could leverage it up, and then you own this property now with 7 liens on it, and then you have to go back and sue the seller. So what I would typically tell you is if you're a buyer, make sure you get that contract for deed recorded somewhere so that it's on title and that any future lenders or individuals are going to know that you have an interest in this property that would stand in front of them. Now, from the seller's standpoint, the risks are going to be as follows. You got a buyer who's responsible for paying the taxes on that property, for maintaining the property. Well, if you're not paying attention to what's going on over there, they could get behind on the taxes and then you could lose it possibly in a tax sale. They could fail to insure their property and the property burns down and now you've lost your house. So there's a number of things from the seller's standpoint, just that the buyer's responsible for, that creates risk for you. The other thing is let's assume that the buyer decides they're going to open up an auto repair shop, which happened with a client of ours. This was not in a contract for deed. This was in a rental contract with an option to buy. But the buyer of this property, the tenant buyer, what they did is they opened up a auto repair yard, so to speak, on this property without notifying the seller, and they contaminated the property because they take all the oil and antifreeze, just pour it in the ground. When it came time to buying the property, they asserted the value of the property was not what the seller thought it was. It was greatly diminished because they had committed waste on that property. And they wanted to buy the property, say it was supposed to be worth $1 million, and they said it's only worth $400,000 because of the environmental contamination. Seller, of course, sued, buyer wins, and they get to buy the property for $400,000 because seller didn't have the right provisions in the contract to protect them. That is why whenever you enter into this type of agreement, if you're the seller, you want to make sure that you have protections from the buyers committing waste on the property. Also, you want to be going out there and checking it out and ensuring that that property is being maintained because title is still in your name. The issue you could run into as well is if somebody gets hurt on that property, who are the attorneys going to sue? They're going to sue the person that owns the property. Because your name is still listed there, it could potentially drag you into the lawsuit. So this is another reason why you want to make sure that this property is held in a limited liability company, not in your personal name. So if that were to occur and the buyer creates some type of risk on that property that rolls back up onto you because someone's injured, that you've limited your liability exposure. These types of agreements, they can be really great in the right situations, but you have to appreciate the risk in going into it. And that is why if you're thinking about using a contract for deed, make sure you find a knowledgeable attorney in your area, in your market, that can then walk you through what the legal requirements are to put this thing together the right way so that your interests are protected. All right, guys, that's it. If you liked the video, smash the like button. Be sure to subscribe to the channel. Take care.